And now for our third panelist, Dean Candelario will discuss the experience of Ateneo de Manila Law School in rolling out the tracking system. So, let's all invite the Dean of the Ateneo de Manila Law School to the podium, Dean Sedfrey Candelaria.
Divina had encouraged you to be part of PALS because one of the most beneficial, I think, impact of PALS through the years, no? And the Association of Law Deans has really been the camaraderie. It has not been as competitive as before. We can be competitive and yet be happy in that context. No? But more than that, it's really the helping hand. No? It's the helping hand. That is what we have been trying to foster among the law schools. Learn from the experiences of the different law schools and in fact lend the others the opportunity to be able to learn from the experiences, bad or good, of the different law schools. So I begin with that tenor and to just share with you this afternoon. We're going to introduce a route that we have taken just about 2 years ago, when I became dean. It was 2011, 2012, actually 2012 proper. Dean Cesar left for the commission about November of that year, so I had to be on de facto office, but 2012. Okay? And 2011, 2012 year was the first experiment on the MCQ. And of course, as you know, we've been going through a series of experimentation with hopefully some stability being seen in the next few years in the bar exams. But one of the first things we tried to do was to revisit our curriculum. We've been 25 years with the JAD curriculum. We definitely were the first to shift. It was Dean Eduardo de Los Angeles who, after seeing the JD curriculum in the United States, decided that it might be high time for the Ateneo Law School to move from an LLB to a JD program. So it was a leap of faith of sort for the law school, and one of the first concerns, of course, by the alumni was that it will affect our bar performance. It's been 25 years, no? Perhaps except for the last few years, it's been pretty steady. Well, we've been registering consistently in the bar, but we've had problems definitely with the mortality, especially the last 4 years. This is known. I'm going through about 81 retakers this coming school year, cumulatively for the last 3-4 years. So it's a very big challenge for us having seen this, and we were trying to analyze. And I think the bar exam session after this would really become very helpful for us to understand, because we had to make sense. I had to deal with alumni. I don't do Facebook, so it helped me a lot to have peace of mind. But you know, you cannot get away with it. People are asking why. Everyone was asking why. I said yes. Ateneo suffered, but the best law schools also suffered, right? There were changes made immediately, as you heard from the UP College of Law. Dean Danny did an immediate cure. But for us, it was a big challenge. We're at the crossroads. 25 years of JD. We think the JD had also brought a lot of advantages to our students. And that's what I'd like to share. Did the JD actually work for us? My statement is it has worked. And we'd like to have it continue working and raise it at a different bar. And this is what we've tried to develop the last 3 years. I started with the syllabus. When I saw the JD program, and I sat, in fact, in the first thesis defense of the JD. I was the first thesis director when Dean Cynthia came on board in 1990. She was looking for a thesis director and said, can you do this? And it was just timely because I did my grad studies in Canada, and I had to write my thesis. In an LLB curriculum, the most that I wrote was about a 25-page paper. I remember Francis Tolentino was my batchmate, so we divided the 25-page paper into 5 pages each. There were 5 of us. That's the most we did, LLB. And Ateneo has always been seen as a bar-oriented school. And so many were worried, no? Will we lose top-notchers? No? Well, it did not happen. We continue to have. We've never missed a top-notcher. Knock on wood. But we said, is it really topping the bar? What are we developing among our students? Memorize the law? How are we dealing with the skills? How are we dealing with developments outside the country? Globalization, you talk about internationalization. It's a big challenge. The university as a whole made a decision to shift calendar. So we're implementing the first shift, which is August, in sync with the rest of the world. But for us, we're saying, what is it for us in the law school anyway? What are we trying to be in sync with for the rest of the world? And we saw that there is some basis for doing that. And I'll try to begin also with that framework. Okay? So can we go to the next frame, please? Yes. We did a consultation, massive consultation among students, among faculty. And it came with about 3 stages. First, we asked around, how do you feel about the current state of the JD curriculum? And when we revisited it, we found out that the electives that were offered for so many years were really electives that were supposed to be in the core. They just broke it down, put it into the electives. And that's why, if you look at the reinforcement of the core subjects, they were reinforced by bar-related subjects. And so some began asking, can we try to do a little more focus perhaps on certain areas of specialized fields of law? And that means reconfiguring. Let's put everything in the electives that are really core in the core subjects. So you will see there's an increase in some of the units. Special penal laws, for example, is huge. We were talking with criminal law department. How many penal laws, special penal laws are there right now? On top of criminal law 1 and 2, 35. That's an elective by itself. And so criminal law professors are really in a quandary. How much do I take in? And now with the bar, last year, whether you like it or not, the most difficult was criminal law, notwithstanding the fact that 90% of the students passed. But it was the most difficult. So we decided to do consultations. That was the first step. And then we decided to do a survey in particular, looking at the electives that might be favorites, maybe favorites. And the stage 3 was really testing it over the summer period, where we had 4 months, where we decided to test whether students who are 3rd year and 4th year, who really will not benefit much anymore from the enhanced JD curriculum, which is to be enhanced with an LLM program. And we thought that that might be an opportunity to test it. But the bar continued to be a problem for us. With the decrease or declining bar performance, the faculty had to be worried about that trend. And we said, how do we strike a balance here? Unless the Supreme Court comes up with a more stable system of testing the law schools, we will always be in a position of moving back to an all bar, but at the same time, we cannot just go back to an all bar. That was a question that we had to decide on. And I think it was fair enough for the faculty to have suggested, let's do both. You can enhance the JD with an LLM program, but at the same time, enhance the core offering. And this is what we try to do. Next, please. So So we did this survey, and we actually did some instruments to find out what are your areas of specialization that you think would be most beneficial. Okay. And from there, this is how we moved on. Thank you. Let's go ahead. If you look at our JD curriculum, as mentioned, no? I was trying to compute right now. Go ahead, please. With this curriculum now, it's a total of about 158, plus you add the apprenticeship and the thesis. Every Ateneo Law student will have to write a six-unit thesis to be defended before a panel on the 4th year. We've done a little adjustment on this because when the thesis was rolled out before, mind you, many students in 1st year, you'll be surprised, who could not even recite very well, write well, but the time they get to write their thesis are very impressive. Some have really landed in very respectable journal articles, even international. It's amazing, no? But it takes two to tango. You have to have a good advisor. You have to have a pool of professors who are really committed to provide also topics. No? And every year, we have more than 150 people. This year alone, we'll have 190 who are defending their thesis. It's the biggest that we have so far. 190. 190. And Director Ampi Santa Maria, who's now heading the thesis program and the Graduate Legal Studies Institute, really has a lot on her hand. But imagine that, to do that, you really have to have a very strong base, no? Of practitioners who can actually feed into the students the most current issues. So, looking at apprenticeship and thesis, can we go to the next screen, please? We have a total of about 180 plus, which will include apprenticeship and also thesis. Apprenticeship is supposed to reinforce the core and even the electives. And that is one of the areas that we will continue to develop, because we found that when you have a tracking system, like you specialize on environmental law, it's good for you to land in a firm or in an NGO that specializes in that field. And second is that that NGO or office will receive you with already a foundation on environmental law. And so there has to be some synergy of sort between your apprenticeship, including your core and elective courses. Thesis is still going to be there. We decided that we will maintain the thesis, and we think that it's a good part of the JD curriculum. Thank you. What were the changes that we did? Labor law and tax law have often been problematic. Labor because of stability in jurisprudence. That's always been problematic, I think, for most of us. Tax because of the technical aspect of tax. And they have been electives for a long time. But we noticed that students who fear labor and tax law review are really trying to go into it. But they are core. So what we did was to put them in the core now. They're all in 4th year now, and increase the number of units to 3 units per semester, except for ethics, which we assume students are hopefully imbibing from 1st to 4th year. All of the bar subjects now are in 4th year, with very little electives remaining for your 4th year. So the bulk really will be seen through the 3rd year offering. Special penal laws, by the way, is mandatory now in 2nd year. We decided to meet up with our faculty. It is an elective course, but we said, put it in 2nd year. After you've done criminal law 1, criminal law 2, then perhaps you're prepared to do special penal laws by 1st semester. So this is what happens in the tracking program. By 3rd year, the student goes into a track. The track can also have a stream, which we will explain. But the track is actually your big chunk of concentration. And when we did the survey, many expressed interest in corporate and business law. So that's the biggest interest. Again, the impression with many Ateneo lawyers is that they're really corporate and business law practitioners. UP has always been really seen as producing practitioners. That's been the impression, even our alumni. We don't have the benefit of a very expensive legal aid program. We're trying to do that, but it's expensive also on our part. We rely on tuition. It's a function also of your income. How much you can expand, how much you can actually pay faculty. So we rely on tuition. Even infrastructure. We really had to earn our own cost for a building, for that matter. It's a tough choice for us. But we think that students can actually be made to choose coming into third year doing certain special areas. So third year, you will have the bulk, which is 2/3 of your electives. By fourth year, you'll have 1/3 remaining. Very minimal already. So we think that fourth year will really be the start of the real bar review. When I was computing our remaining bar review months for next year, this year is fine because we had extra months, no? But next year, we'll have less than 5 months. And so we tried to scare our students and said, fourth year is the start really of your pre-bar. Don't take fourth year lightly. And we will flunk if you deserve to flunk. No? In the past, many think that by the time you get to fourth year, it's a breeze through. But we said that can no longer happen. We want to prepare you well. Your pre-bar is really going to be a pre-bar when you reach graduation and go into the pre-bar review. But the real bar review begins by fourth year. And we hope by doing that adjustment, we'll be able to address the problem of the declining percentage in passing. So, let me just show you a frame. I'm sorry, but in the material I gave you, it's in one of the pages. No? You will see the ladder of, I think, electives and core leading to a possible /LLM program. We are envisioning the possibility of encouraging our students to do an LLM program right after the bar. Not before the bar, right after the bar. But the core electives will really prepare you for the bar. The special tracks will prepare you for a possibility of an LLM. We will credit your LLM requirements, no, as far back as what you have taken in third year and fourth year. So you have already almost a semester ahead. What happens after the bar? Well, students go to Boracay, they go to Palawan, when they go abroad, no, they wait. Nahihiya magtrabaho kasi baka mamaya abutan ng result ng bar, wala yung pangalan. So maraming takot. So I said, so what do you do? Those are idle months for you. So we said, why don't you do an extra month perhaps, either with the Ateneo or hopefully, and we've been able to enter into some agreements now with some universities abroad, do 1 semester or an extra semester and a half in another university where you get dual degree. You get a degree from the Ateneo, you get a degree from a partner university. Today, we have one faculty member, and because of the need also to help our faculty acquire a Master of Laws degree, we've enrolled her in our program, and she'll be going to Kyushu University on an international law program. And she'll have the benefit of 2 degrees, Ateneo and Kyushu. The other one forthcoming is hopefully with the UK University, about 1 or 2 of them. For me, that was a baptism of fire. I think I mentioned in the Cebu conference that one of the wake-up calls for us, at least at the faculty, when we're trying to explore dual degree programs, was really the kind of preparation that law schools here in the Philippines would need in terms of having to do equivalencies. No? See, we met with about 12 UK universities, and this was an offer for a possible dual degree program. And I've seen, of course, the kind of rigidity that you have to do with as basic as your syllabus, with the preparation of your faculty, if there's a possibility of faculty exchange, no? Or students being received here from other universities. It was quite a task, and for me it was an eye-opener. And when I went back, I told our team doing the tracking and the syllabus development that we do have to own up our capacity towards curriculum development. So UK, another one in the offing, is possibly Malaga University. And we're trying to look at North America, hopefully, with Canada and UK, Canada and United States. So we will choose. We cannot be partnering with the big ones at this point, but we will look at modest programs where our faculty and some students may be able to do this in a dual degree program. Now, let me jump to the just an idea of how the core subjects and the electives actually come into play. So we have 18 units of electives, where 12 will hopefully be done by third year, and 6 would be done by fourth year. Thank you. Can we move on? Now, here is the distribution of core and electives right now. If one were to look at the frame, first semester of third year, you have a total of 26. It's really higher than the LEB model curriculum. Second semester is 27, a total of 53 for the year. And fourth year would really be heavy on the core, plus a few electives for that matter. Okay? A total of about 47 for fourth year, the whole of fourth year. So it's really quite heavy. Okay? Just on the tracks, let me just give you an idea on how the tracks have been developed. Thank you. So the biggest chunk is corporate and business law. I don't know, for some reason, students really, at least right now in our area, are very much attracted to corp and business. The second biggest is dispute resolution, and the third is international law and development. These are the tracks, but the streams are also important to look at, where they can choose also within the tracks more specific areas. Thank you. Yes, go ahead. So in the area of corporate and business law, you would have corporate finance, intellectual property, corporate litigation, and dispute management. For dispute resolution, you have litigation and ADR, alternative dispute resolution. And for international law and development, you have public international law, international economic law, international environmental law, and international human rights law. My key, I think, is in the development of the departments. So for a long time, we had nominal departments, the 8-bar subjects, but now we have decided to activate the heads of departments together with the vice chairs and also a secretary together with the rest of the membership. And that's where we have done a lot of work over the summer, trying to empower our more senior ones. And I was listening to Dean Hilo Divina earlier. How do you deal with, of course, people who have been there longer than you, your former teachers? Well, they will be there. It's very difficult to deal sometimes, but we try to deal with them with tender, loving care. So they're chairs, put them as chairs, put very active, younger vice chairs, and get very young, very young errands, errand faculty who will do the secretariat work for them. That's the way to deal with it, perhaps. But perhaps I think we also have to respect the wisdom that we get from the senior faculty, because we learn a lot from them, and I think they are also due for recognition by giving them the type of treatment in our faculty. So now, we have mandatory choices for students. You choose a track, but the streams would be optional. Students might just want to stick to the general track, but you have free electives. No? When you say free electives, it's anything under the sun in the three broad tracks that you want. But you have to choose a track. And let's take, for instance, Corp and Business Law, just to demonstrate this part, no? Thank you. Can we move to a demo? So, let's say Corp and Business Law. One can just choose to be on the general course. But if you want to do streams, you can have your foundational courses and also your cognate courses. So, this is going to open up more specific areas, no, of law practice, and I think with the wealth of part-time practitioners, no, they can also have the opportunity to choose certain areas of interest that really could become an opportunity for students to take in the so-called streams. Okay, thank you. Can you move on? Yeah, move. Now, this is perhaps something I will end up with, and I think one of the areas for strengthening the faculty is really to open up the capacity of the different departments. No? I was also looking at the proposal to prepare our faculty for updates. No? They're very busy, and Joey here, Attorney Joey Felenia, belongs to the Commercial Law Department, had proposed to work very closely with our library, with our librarian, to help a group of faculty members really be updated up to the latest decision yesterday, or updates on laws, regulations. That I think is a very good way to make our faculty, who are mostly part-time, also updated on the latest development. They may be updated in practice, but when you now look at materials that may be made available to them and for their students and to develop their syllabi, this is one synergy that will have to be explored. And I think most of you, in cooperation with your other departments, can do this. So right now, we ended up with doing our reorganization of the departments. And in the matter of faculty recruitment, we have asked them also to vet any applicant, let's say in tax or in remedial law. So there's a vetting process, not just the dean. So I give them an opportunity to review the credentials also of those who might just want to teach. And we're looking at succession of professors. Very few professors now are able to teach commercial law. Let's say that's a big chunk. So we're trying to do experiments right now to build our faculty who may eventually just go up the ladder and teach commercial law review. Our biggest problem now is, of course, Professor Jimenez. Professor Jimenez is practically doing the entire 4 sections. So what we did was to explore the possibility of one section being cut up into about 3 or 4 professors to teach the commercial law track. So that is an area where there is a need for succession, and I think the departments here will be able to help us along that line. Okay. Well, all told, I just want to leave you with this last frame to say that it's very challenging. With all the comments on the side, we said, we will put a stake on this. We will see the fruits of our labor in a few more years, but it must go with also a review of the bar exams. Because we cannot be tied up every now and then to say, well, this is the state of the bar exam. You have to make sure that your students pass. Yes, we want to do that. But on the other hand, we also want to make a great living. There's such a demand now for lawyers in the Philippines to be doing also international law practice. I'm sure many of you know of young lawyers who are really in the region, in Myanmar, in Vietnam, but their jump-off point is Singapore. They're hired by Singapore law firms and distributed. One advantage we have is the English language. We do have a great comparative advantage in the region, and we must capitalize on that. But who will study ASEAN anyway? Would you put it in the curriculum? If it's not asked in the bar, you think students would care to do that? I mean, it takes two to tango. And we hope that the PALS can send a very strong message that while we have different approaches right now, obviously there's a common interest for us to see a more stable system of bar examinations and making sure that the Supreme Court also dances with us in this demand for the Philippine lawyers and law practitioners to be competitive globally. And I think, hopefully, they'll listen this time. Thank you very much.
And now we would like to have an open forum. You may ask any questions whatsoever with any of the members of the panels. Any questions, comments, suggestions? Yes, please. Could you please mention your name for everyone's benefit first? And where you're from?
Dave Pedona was teasing me a while ago. So, baka nahimik wala ko si Dean Ceballos. But here I am, guys. Okay, good afternoon to you all. And Dean Nilo Divina, maraming salamat po sa buwang trip. Palakpakan po natin si Dean Divina. I would like to address these issues to the LEB. But first of all, I'd like to commend UP Law Dean Danny Concepcion for a very passionate, Taglish speech because UP is the only school that enjoys full academic freedom from LEB. Ganun lang po kasi yun. Kaya tayo lahat, we're under the auspices of the LEB. Now here goes my few pointers to the LEB guys. Our school, PCU, has a different market from Ateneo, UP San Beda. We cater to transferees. Alright? Okay guys, yung masiba nyo sa mga branded schools, let them come to us, we make them lawyers. And we have been successful so far. Now the problem that besets us always is this. The units, let's say from San Beda, would be 4 units, and sa amin naman 3 units in one subject. So the poor guy who's about to graduate will now have to take additional subject. That's a minimum of 3 units. Now what's the proposal? Can we make the distribution or the corresponding units per subject uniform, at least for the core subjects? We don't mind about the electives, but then we can set up with the electives easily. The problem is, again, as I said a while ago, Rev Law for us is 10 units. Doon sa pinagalingan ng eskwelahan, 12 units. Sobra naman, halimbawa. So siguro, sa core subjects, my humble suggestion is to make it uniform for all those schools. So that when they transfer, because actually nobody wants to be kicked out, or nobody wants to transfer for some reasons, hindi na mahihirapan yung estudyante at yung eskwela na tumatanggap. Secondly, we have the Supreme Court syllabus. My suggestion po is this: why don't we pattern the units of the curriculum on the basis of the percentages assigned by the Supreme Court? Halimbawa po, ang remedial ay 20%. O di yung ating curriculum, gawin natin 20%. Because all of us here, we all have one mission and vision. What is that? Churn out bar passers. At least temporarily, and after they pass the bar, they can go to anything they want. I mean, law school abroad, or take economics, etc. But for the meantime, let's be more pragmatic and realistic. Dapat makapasa mo muna yung estudyante natin. Kaya kung nagpapamasok sa law school yan, para kung makamaging abogado, baka sakali. So, ang akin lang sa akin gusto sabihin, kung sinarap na Supreme Court, 10% ng civil law, 20% ang ganun, 5% ng ethics, yung curriculum dapat pattern after. Hindi yung we digress eh. Like, I don't see the logic why a law school would have Rem Law 1 review, and other law schools would have Rem Law 2, 1 and 2. and 3 pa kayo ba? So, I think we have to be in sync with the Supreme Court's distribution of percentage because we cannot do away with the Supreme Court. Yun ang bibigyan ng market exams yan. Next item po ay ganito. Do we understand that the law schools also exercise quote-unquote academic freedom? Halimbawa po ganito. I am not in favor of civil procedure and criminal procedure offered in second year. Why? Yun ang bagong pasok ng first year student. And everybody will attest to this. Pag binigyan mo ng kaso, ano sasabihin sa decision? This is a petition for review under Rule 45. Paano ang kinalalaman ng first year student na magbabasa ng kalahating desisyon na 20 pages, all about procedure? Eh di turo mo na sa kanya sa first year pa lang, nasa ganun, habang siya umaangat from first year to third year, the guy knows procedure very well. Hindi yung ibibigay mo sa kanya sa third year. And yet, nagbasa siya ng kaso na 20 pages, 30 pages, which is very common, eh kalahati ng kaso, procedural mo eh. And again, hindi mo lang pwede sabihin sa bata, huwag mong basahin yung kalahati. Ha? Paano yun? No, so, ang akin na ho eh, give us the freedom, the schools, to, let's say, adopt a modular style of allocating subjects. For example, sa medicine. Sa medicine, no, everything about cells are being taught in one sem. Siguro sa law school, everything about civil law, everything about procedure, in one sem. Nasa yung utak ng bata, tuloy-tuloy. Everything about procedure, yun pala. Bakit? May similarity yan eh. Yung plate, yung civil procedure, information, or complete affidavit, in K-Pro. These are similarities. So, I know that the LEB has to hurdle a lot of birthing pains, and it might not take a few months, but a lot of brainstorming for us, the PALS, with the bright lawyers here, and the LEB, to do a lot of rethinking. Hindi ba? So, these are just my few points, and I hope mapag-usapan pa po natin ito in the long term. Thank you.
Thank you very much. Dean Ceballos.
Freedom to increase it to 4 years. In fact, I noticed that some of them have increased it to 4 years. So, also with respect to Dean Ceballos' comment regarding aligning the curriculum to the percentages of the Supreme Court, well, as I just said again, the law school has the option of enriching the law curriculum. In remedial law, for example, I noticed that it has fewer units than civil law review 2. But I think this is a concession to the fact that there's a plethora of subjects that will be taken up in civil law review 2 rather than in remedial law review. For example, I do remedial law review, or I did remedial law review, and I found that in reality the subjects there are lesser than civil law review. So that could be one of the reasons why remedial law review 2 has a lower unit requirement than civil law review 2. On Dean Ceballos' comment on modular delivery of certain courses, well, we can discuss that, right? As of now, the rules do not sanction a modular delivery of legal courses, but if a case can be made for modular courses, then we at the LEB would be open to this fine-tuning. Thank you.
Yes.
Restricting the curriculum by a regulation may not be wise. It will stifle academic freedom of law schools, which are institutions of higher learning. You may rally reasons for one and rally reasons for another, and we may not end. In UP, the opening of a course, whether it is elective or core, requires a very long process. It goes through a lengthy procedure that culminates to the University Council. Hindi ganun kadali mag-open ng course sa UP. Kung sa kaso ni din si values. Ito ang suggestion ko, pinakamadali. Why don't you look at the curriculum of the school na pinanggagalingan ng mga transferees mo? If many of your transferees come from Sambeda, ikaw bang mag-adjust doon sa curriculum ng Sambeda para paglipat ng mga estudyante from Sambeda, wala nang problema sa eskwelahan mo? Huwag mong pilitin yung Sambeda na magbago ng curriculum para paglabas ng estudyante, walang problema. Suggestion lang, suggestion lang.
Babago yung may pangalan ng eskwelahan sa Beda Annex. Thank you.
Or maybe there's nothing which will prevent us, schools, from coming up with an arrangement among ourselves. Halimbawa, sino ba yung mga nasa university bed? Baka gusto nyo kayong mga nasa university bed, kayo sa isa nyo nag-iikot-ikot yung mga estudyante, baka gusto nyo kayo-kayo ang mag-usap para yung curriculum ninyo na mga magkakalapit magkaroon ng alignment. Pero huwag natin gawin ito through regulation. Kasi maraming effects yung regulation na hindi desirable.
Father Saturnino Oris University, I'm the dean. So I come from a region where there's armed conflict. And it's also one of the poorest region in the country. And so, as Dean Divina said, teaching. So yung ginawa po namin, nag-teaching din kami. The legal education in our school is really wears the lens, the indigenous people's lens. So when we try to teach our courses, we try to incorporate things that we need in order to serve the indigenous people. But we saw in our journey, like for example, a lot of conflict there that will erupt into violence start from boundary conflicts among tribes. If there is no peaceful intervention, they will really erupt to really very, very tragic armed conflicts, and there are lots. It does not just end up in the media. And we saw the role of the law school because we were able to journey with NCIP in settling a boundary dispute, but not using the mainstream, quote-unquote, legal system, but their customary laws. But in the process of doing that, we have to equip our students with things that they don't learn in the curriculum that is before us, like conflict sensitivity and conflict transformation. The fact that there's legal pluralism on the field, like among Manobos, they don't have one legal system or customary law. Manobos have different groups, and those groups have different legal systems. So these were the things that you have to equip your students. But in the process of equipping our students, I got a backlash. In fact, during the exit interview, one of my students said, I was so insensitive. I didn't think about their bar preparation because I was taking time out of the 4th year just for them to go into capacity development activities on conflict sensitivity and conflict transformation. This is already for free. We didn't ask them to pay. But they did not like it so much because the bar is already around the corner. And so I got a very bad evaluation at the end of the year as a dean. And so my question is, in fact, I could see the recurring theme. It's the bar that's really restricting our desire to be relevant in serving our country and of course the world. So my request to LEB, what is the LEB Commissioner Regal doing in order to bring forth to the Supreme Court that indeed there's a need already to change the bar exam, maybe because the Legal Education Board is a regulator also. A request coming, like bringing our voice also to the Supreme Court through the LEB might expedite the changes in our bar examination so that we can better serve our country.
Ang nagawa na. Sino sumuporta dun sa ating resolution? Okay tayo, no? Philippine Association of Law Schools. Unanimous. Integrated Bar of the Philippines supported it unanimously. The Philippine Bar Association supported it with a unanimously adopted resolution. The Philippine Association of Law Schools. At alam ba ninyo na pumasa na ito sa Bar, Mater, and MCLE Committee ng Supreme Court itself? nakahando na lang ito para i-tackle ng NBank, hindi pa nila botohan, hindi pa nila i-discuss. Kasi busy-busy sila eh. Ito rin di Manila pa to. Hindi pa nila... busy-busy raw sila. Para bang tayo hindi busy.
Yes, the Legal Education Board is fully supportive of this stand taken by the PALS among others of reducing the number of subjects in the bar. So to free up for electives. So I think your case is very interesting. It could serve as additional ammunition for convincing the Supreme Court that we should reduce the coverage of the bar.
Why don't you write it down, Jojo? And then I will write a letter to the Supreme Court to follow up. And maybe I will attach your letter as an additional argument for them to hurry up and adopt immediately the proposal.
In fact, Commissioner Higuera, we would also want to have an audience with the LEB because we really would want to formalize also that request to the LEB regarding this. So, with Dean Conception's suggestion, then that's also very good, sir. In fact, we're already writing the paper, so hopefully we'll be able to.
Yes.
Thank you so much.
In fact, I can also speak from my experience. I have been to schools in Zamboanga, in Western Mindanao, and they can tell me of the role played by law schools in upholding the rule of law. So, like also in your case, so this would allow us to concentrate on these subjects: indigenous people's right law, humanitarian conflict, which fulfill a very important role in in certain areas in our countries. And I mean, from your experience, the bar has a prejudicial or deleterious effect at bottom on the rule of law or peace and order. So, I mean, there's a connection, however indirect, but it's a good persuasive material to the Supreme Court.
Yes, sir.
I'd like to thank you for giving me the opportunity to be a part of this discussion. And I must say, I was really impressed by the panel, and I feel like I should package them up and take them to Australia, show people there what real discussions about legal education are like, and also to show them the diversity and innovation that's occurring here. I've been really impressed, and I must say, thank you very much for that presentation in each of their different ways. A couple of observations. One about the LLB, which I would defend to the death. And I thought the presentation by the Dean comparing the LLB and the JD was fascinating, and I learned a lot about the JD, but I'm still prejudiced against it. And not envious at all. And the reason for that really is because when I went to Australia, I did a degree in University of California system, Thesis college, many years ago, and got an LLB. When I went to Australia, I heard these debates about the scholarly and the professional, and I can gladly report that in Australia, for the most part, certainly I would say that my university was one of the main innovators. There we consider that a scholarly education is the best kind of education for legal practice. And I think that I see a lot of the work that's being done here as evidence that idea has been taken on very strongly here. So I don't see any problem, and in fact, any problem introducing scholarly approaches to the law, a broader contextual analytical approach, a scholarly approach. And in our LLB, we always required an honors thesis. So it's not just in the JD that you can do your thesis. Second point. Now, some of you will have heard me speak at this conference in Cebu 2 years ago, so if I'm repeating myself, I apologize, but I know there are people here who weren't in Cebu. One thing I haven't heard mentioned here, and I admit that I don't know enough about the specifics of the courses that we're talking about, but I haven't heard the word history mentioned. And to me, basically, and I like what Nilo said about teaching you become an expert. My LLB back in the 50s was a very narrow one, very black letter, very instrumentalized approach to the law. My legal education started with a course which we gave to first-year students, History and Philosophy of Law. And it seems to me that today, in a kind of postmodern world, or one that is infected by concepts of postmodernity, there's a great deal of chaos in our education, and a great deal of what I would call alienation amongst young people. And I would argue that history is the discipline that pulls all this together. All of what we're talking about, law has to be understood, in my view, within the history of not just legal history, but the history of the development of Western and increasingly more broadly civilization through feudalism, capitalism, and so forth. One of the main problems today, it seems to me, is the peasant-mindedness of students. And to give them that historical background, they can then understand the alternatives, the possibilities, that what is hasn't always been, and necessarily not permanently with us. So I would accept the invitation to make a suggestion to the LLB, LEBs, that serious consideration must be given to requiring a strong element of history to exist within the curriculum. And just one last word for those who don't know about it. We in Australia do not have a bar exam. And the freedom that gives is wonderful. And maybe later or tomorrow we can talk about some ways of tweaking the system here that give increased freedom to those in higher education who deserve it and to students who really need it. Thank you.
Gentlemen, so the LLB program has been a scholarly program. Although I think they have the advantage there of not having a bar examination and having more academic freedom. Here at the LEB model curriculum, we have the so-called perspective courses, which we could say would afford a broad scholarly or a liberal arts background to our to our law students. So we have courses like philosophy of law, legal profession, and rounded areas that it would help to put more scholarly content with the content of the bar examination to be reduced. But as it stands now, we have a lot of restrictions because of the bar. But your observations are well taken, sir.
2 points. First, I just would like to react on the presentation of Dean Sedfree. Because I'm a graduate of the Ateneo de Manila. I think, if I'm not mistaken, I'm one of the first batch who graduated under the JD program. I think Dean Sedfree doesn't recognize me anymore because I'm now thrice my size before. I have improved so much. Just a reaction a little because it saddened me to find out that in the evaluation or consultation, it came out that the preference of the students are now on corporate and business practice. Yes, because I used to think that the Ateneo actually churns out lawyers for others and not really for business. I hope there's some considerations aware for that. But my point really is, I'd like to support the suggestion of Dean Ceballos. May I know if it's the first time that matter about putting procedure in the first year? Is it the first time that that's been brought? Because if it is, or it's the first time. Because if it's not the first time, then I'd like to know why it hasn't been considered yet, because that's really a very important matter. Even when I was a law student, I really found it difficult to understand the cases. When, for example, in the first sentence you would read, this is a petition for review of certiorari. What is that? Even on top, when you're confronted at the very first sentence with something that you don't know, then everything becomes difficult.
Who have that kind of value within that discipline. So it requires a lot of creativity on the part of the law professors now to inject that. Even ethics, no? Ethics, for example, it cuts through. It must be taught in a cross-cutting manner in the different fields of law practice.